Court calls the case People versus Sky Jones. Sky Jones. Oh, great. Just can't get a break.
Don't worry. No compelling or anything here.
Mr. Public Defender of Vitello on behalf of Mr. Styron, who's going to my left. Well, let's talk to the judge about that. Right? We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. State your name.
my name is Thomas Styron. I live in there.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Court calls the case People versus Sky Jones. Oh, great. Just can't.
Court calls the case of People versus Sky Jones, and the defendant immediately creates tension by insisting he wants to represent himself. The judge tries to clarify the charges, but the defendant refuses to give direct answers, questioning whether he is even the person named in the complaint. When asked if he understands a fleeing and eluding charge, he argues about legal entities and identity instead of responding clearly. The judge warns him to stop smiling and laughing, threatening contempt time if he continues. Despite multiple opportunities to cooperate, the defendant keeps challenging the court's authority and refuses straightforward answers. The judge finally orders him taken back to holding until he decides to cooperate, making it clear that continued disruption will result in 30 days for contempt.
Get a break.
Don't worry. No compelling or anything here.
Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor, punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through with the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
Setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of all,
I'm the
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Sest QVA trust matter involved in this? Is my social security number attached to this at all?
Siren, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming
learn,
that
you
there's
will
some
learn
sort of
how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me
me
to be somebody I'm not.
or this
You
institution.
have no evidence
It will
even
not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion?
After being brought back into the courtroom, the judge formally outlines the 3 felony and misdemeanor charges, including fleeing and eluding, resisting an officer, and driving with suspended license. The judge explains his right to counsel and warns him that representing himself means he will be held to the same standards as an attorney. The defendant continues raising arguments about trust and identity, questioning whether the court has authority over him. The judge's patience runs out, reminding him that disrespect will not be tolerated, referencing his behavior during the previous hearing. The court finds him in contempt and sentences him to 30 days in jail. The judge firmly states that he will learn how to conduct himself properly in court.
I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
Lead, there is a violation as well. That should be in the file.
That's correct, Your Honor. Defense counsel, I did have a chance to discuss that. I told Mr. Turkis I wasn't sure if the court would want to move forward with the plea today.
I'm not going to want to.
Regarding the violation, there would be an admission. And with that admission, he has worked with CMH and gotten into additional programming. He was dropped off here today by
my counselor,
and he wants to continue to have negative tests, but obviously there's the positive test that just happened.
Well, the problem that I have is that the last testing that he has, he's been unable, then he missed a sample on October 6th. I'll accept his admission, but then on October 6th, he's negative, but then he just comes back positive for cocaine.
There was issues with his rent, and he's worked with his counselor, and he also wants to address the court.
Go ahead. Well, I think he's. Go ahead. What do you want to tell me?
Yeah, as far as what I can tell you, to being bluntly honest, well, I had an eviction on my door because I had my son living with me. So after that, I got that fixed. October the 7th, I think. But I was going through a bad time situation, so I take full accountability for the situation that happened. But when it comes down to, I got a bleeding ulcer. So when I called Cheryl, I told her I couldn't make it in because I was going through a bad spot, but she didn't answer the phone. So I still came in, and I tried to use the bathroom. I got bipolar depression, anxiety. I waited a whole hour. And because she told me I can wait in there. So I waited an hour in there sitting, and I still couldn't use the bathroom because of my respiratory system. So it's been going bad, but it's getting better because ever since that I've been coming to drop, I was using alcohol, but ever since I've been coming to drop, I haven't used no alcohol. So my body is getting better. So when I went in on October the 15th, I dropped, and like I said, I take full responsibility for the situation that happened, but I have been clean, but I went through a rough patch, a little episode. So, I mean, I'm just being honest. I take full accountability. I made a mistake. I went down there, I told my counselor. So my counselor, they didn't want me to ride the bus. So they brought me here.
You have an upcoming appointment?
She made an appointment for CMH to get, I got an appointment for CMH to go in there and talk to them. She said she's going to stay there for like 4 or 5 days from now because I had to come to court. She wanted to take me today, but instead she had to bring me here.
What's your appointment date?
She says she's going to put it, she put it in the system, but she says she's going to get it on her.
Where did the cocaine come from?
In a separate bond violation hearing, another defendant admits to relapsing after testing positive for cocaine. He explains he was facing eviction, dealing with health problems including a bleeding ulcer, and struggling with bipolar depression and anxiety. He claims he tried to comply with drug testing, but was unable to provide a sample during one visit. He takes responsibility for the relapse, saying he got around the wrong people during a difficult moment while traveling to see his brother. He insists he has since returned to counseling, stopped drinking alcohol, and has been receiving daily wellness checks. He pleads for another chance, promising the court he is committed to staying clean.
Well, to be honest.
Okay, let's start there.
Yeah, being honest, like I said, I've been doing, Your Honor, I'm being honest. I want to be honest. I've been doing fine. I picked up a little weight, like Miss Marilyn, my landlord, she said, you've been doing fine. But I just got into a bad spot in my life, and I'm just being honest. I just want to be honest. I don't want to lie to nobody, and I made a mistake. I just made a mistake. But after that, I've been going down there talking to my counselor every day, and everything's going swell because they're keeping tabs on me. They do wellness checks at my house because of my bipolar. But what happened was I had got around, I'm taking accountability, but I just got around the wrong people when I went out and was hanging out the one time I did hang out. And lately I'm an introvert. So I just be in the house. So I just got beside myself. I'm just being honest. But my counselor's been with me every day now. And I've been staying in the house, and she's taking me to community health. And everything's going well. Miss Marilyn, my landlord, she's been coming up checking on me, and everything's been going well. They take me to the grocery store.
Your Honor, if I can just add in here, he had four negative tests. There were the two that you indicated, the refusals. He somewhat explained that he had a missed sample. He was negative, and then we had the relapse. So there's, other than the unable or refusing, he is testing negative. There was the most recent test that was positive. What I'd be asking the court today would be if he can get another negative in between now and the next court date. Obviously, that's a very good indication that he is telling the truth and he had a bad night with the positive test. But
I went and told my counselor, and because I quit drinking alcohol, and like I said, I've been gaining weight. I've been doing everything good. And I went and told Miss Jenna and Miss Marilyn. And after that, they've been coming to check on me every single day. And I go downstairs, I play ping pong, dominoes, and they read books with me. And I've been doing everything right. And I called my mom. My mom said, dress nice and be honest to you, because you're a good judge. So I just came here. And I'm just being honest. I don't want to lie.
I know, but I still don't know where the cocaine came from.
Were you hanging out around with people?
I really don't never leave out the house. Can I be honest with you? Okay, my brother had a heart attack, right? This ain't about my brother though. My brother had a heart attack. So what happened was I ended up catching the bus on my way to go see him downtown in Arbor. On my way to go see him. Didn't make it to go see my brother when he came out of coma. Because I get downtown, like my mom don't let me ride the bus. I get downtown, see some guys I know. Before you know it, this the situation to end up. Boom, my mom called me, tell me get back home. I go home, and I've been in the house ever since. Besides just going to report, because I really don't never come out the house because after what happened to my brother when they killed my brother. So I really just don't like to be out the house. I got caught in a bad spot around the wrong people, and that won't happen again. I promise. I give you my word on that.
All right, I'm done.
I'm
gonna revoke his bond. I'll adjourn it out to next week.
Okay.
And so I'll adjourn it out to the 30th, 2025. And maybe by that time you can give me a straight answer. I'm not gonna take his plea today. I'll hold on.
No, I said I did wrong.
Defendant is committed to the violation. Defendant's remanded. Southbound.
We'll come back.
Can you grab my jacket right there?
Yep. I'll come and see you in custody.
Thank you.
Despite the emotional explanation and defense counsel highlighting several prior negative tests, the judge focuses on the recent positive result and the inconsistent answers about where the cocaine came from. The court expresses frustration, stating it still has not received a clear explanation. Concerned about accountability and compliance, the judge ultimately revokes the defendant's bond and orders him into custody. The hearing ends with the court setting a new date and instructing officers to take him into custody immediately, leaving the defendant facing the consequences of his relapse and hoping for another opportunity to prove himself at the next hearing.